I am delighted to introduce you all to our keynote speaker for today's event, Professor Melissa Murray. Professor Murray is the Frederick and Grace Stokes Professor of Law and Faculty Director of the Women's Leadership Network at NYU School of Law and a leading expert in the fields of constitutional law, reproductive rights and justice, family law, and criminal law. Previously, Professor Murray served as the interim dean of Berkeley Law, and after law school, Professor Murray clerked for Sonia Sotomayor, then a judge of the U.S. Court of Appeals for the Second Circuit. Professor Murray's accomplishments are abundant, and we're so glad that she's able to join us today to discuss how the Supreme Court can use race as a rationale for overturning well-settled precedent like Roe v. Wade. With that, I would like to offer a warm welcome to Professor Melissa Murray.
Thank you so much, Emily, and thank you all for having me. It's nice to be there in Philadelphia with all of you, even if it's only virtually. I want to say first how grateful I am to the Law Review for inviting me to give this keynote lecture. I know that Drexel has some wonderful reproductive rights and justice professors in Professors Cohen and Kikura, so you really didn't have to go far from home for real expertise. So I am incredibly honored that you thought to think of me when you had this abundance of riches in your own backyard. So thank you. And thank you for your incredible hard work in putting together this fantastic symposium today, and especially to you, Emily, for all of the hard work that you've put into this over the last few weeks. There's a lot that could be said at this moment about the current landscape for reproductive rights, but this lecture looks to the past as a lens for thinking about our present and pondering our future. The lecture that I'll give today is drawn from an article that was published this spring in the Harvard Law Review. As many of you know, the recent changes in the composition of the Supreme Court have left many fearful about the fate of abortion rights. More particularly, many worry that the court is well positioned to reconsider and ultimately overrule Roe versus Wade, the landmark 1973 decision that famously recognized the right of a woman in consultation with her physician to choose an abortion. In this paper, I argue that these fears for Roe's longevity are well-founded. But I argue that the threat to Roe may not come from well-worn arguments about the decision's textual fidelity or the workability of the abortion right. Rather, as I argue, the emerging threat to Roe comes from a surprising direction, the ongoing quest for racial justice. So with that in mind, let me roadmap the talk a bit. First, I want to say a little bit about the origins of the paper, and in particular, Justice Clarence Thomas's concurrence in Box versus Planned Parenthood of Indiana and Kentucky, a 2019 case, which is at the heart of the argument. In doing so, I want to focus specifically on the paper's three principal contributions and why I think they're important. And so I'll discuss how the Box concurrence may lay a foundation for overruling Roe versus Wade on grounds of racial injustice, and I'll talk a little bit about what that might mean more broadly for our understanding of the court, our understanding of reproductive rights, and our understanding of racial justice. I want to talk about the history that Justice Thomas sketches in his concurrence and my effort to provide a more complete history and why that elaboration is both important and necessary. And then finally, I will say a little bit about my own intuition that the Box concurrence is not simply critical to the future of the court's reproductive rights jurisprudence, but to its race jurisprudence as well. So first, about the genesis of the paper. In May of 2019, the Supreme Court issued a per curiam opinion on the shadow docket in Box versus Planned Parenthood of Indiana and Kentucky, a challenge to two Indiana abortion restrictions, one of which was a trait selection law that prohibited abortion if it was intended for purposes of race or sex selection or because of the diagnosis of a fetal anomaly. Although the per curiam opinion granted certiorari and upheld one of the challenge restrictions, it denied certiorari as to that trait selection law. The denial of certiorari prompted Justice Clarence Thomas to write a separate opinion. And that might have been the end of things. Justice Thomas told his colleagues that they could not avoid the question of whether such trait selection laws were unconstitutional forever. But Justice Thomas did not stop there. He continued, crafting an opinion in which he conflated the history of eugenics and the birth control movement with the history of abortion. As he explained, Margaret Sanger, the founder of Planned Parenthood and the modern birth control movement, worked hand in glove with the eugenics movement to spearhead efforts to expand the use of birth control within the Black community, ostensibly for the purpose of targeting and stamping out Black reproduction. As evidence of this joint enterprise, Thomas noted the disproportionate rates of abortion in the Black community today, the contemporary residue of this earlier effort to market family planning measures to the Black community. He then circled back to the challenged Indiana trait selection law, observing that such restrictions were merely the state's modest attempt to ensure that abortion did not fulfill its quote unquote eugenic potential to eliminate unwanted characteristics or traits. The concurrence received some attention, but it was quickly overshadowed by other major developments at the court. But I remained absolutely fascinated with this case, in part because it seemed to touch on so many of the issues that I have been focused on in my own research, including the changing discourse around abortion, both in doctrine and in society. I've been very interested in the ways in which the reproductive justice movement has salted the traditional discourse about access to contraception and abortion with concerns about race and class inequality. And as reproductive justice advocates have argued, impositions on the abortion right are not just assaults on women's autonomy and equality. They disproportionately impact women of color and poor women. And as such, they should be understood as posing intersectional harms. It struck me as I read the box concurrence that Justice Thomas seemed to recognize the way that the reproductive justice movement had helped to shift the debate about abortion and reproductive rights to one that engages with race and class as well as gender. In this regard, if the reproductive justice movement, in tandem with the reproductive rights movement, is about arguing that abortion rights are not just about white women, but about poor women and women of color, that is, restrictions on abortion are not just about gender injustice, but about race and class injustice as well, well, then Justice Thomas's concurrence turns that logic on its head by countering that the real racial injustice is not what abortion restrictions do to women of color, but rather what abortion does to communities of color. And Justice Thomas is well positioned to make that intervention. He's been a stalwart institutionalist in terms of his objections to the abortion right, and he's also the person on the court who often raises questions of race and racial injustice, including in cases where race is not obviously salient. And it occurred to me that this concurrence was not a one-off from Justice Thomas, as some commentators had suggested, but rather a concerted effort to seed new ground in the abortion debate. So what might that new ground look like? On one level, the concurrence bolsters a defense of trait selection laws that has already been percolating in the lower federal courts. Indeed, in the Seventh Circuit's disposition of Box, Judge Frank Easterbrook wrote a dissent, which then Judge, now Justice Amy Coney Barrett joined, in which he suggested that trait selection laws might fall outside of the scope of Casey and Roe because those cases had never considered abortion restrictions that were not aimed at promoting women's health and instead were positioned as fetal anti-discrimination measures. The Box concurrence provides additional support for the idea that state-level restrictions on quote-unquote eugenic abortion function as anti-discrimination measures, and as such, were not contemplated by Casey and Roe. And to be very clear, the Box concurrence has already been cited for this position, both in amicus briefs filed in challenges to trait selection laws and among members of the lower federal courts. In January of 2020, the Eighth Circuit, in a case called Rutledge, invalidated an Arkansas trait selection law that prohibited abortion where there was a ban on a Down syndrome diagnosis as the basis for that choice. They argued that it functioned as a pre-viability ban in violation of Casey and therefore was unconstitutional. But even as the Eighth Circuit struck down the law, the majority opinion also noted that the court in time could revisit whether Casey applied to trait selection laws at all. And in a concurrence, Judge Bobby Shepard explicitly cited the Box concurrence, noting that Casey's viability standard does not and cannot contemplate abortions based on an unwanted and immutable characteristic of the unborn child. So it's clear that the concurrence has immediate implications for challenges to trait selection laws. But as I read it and ruminated on it, it seemed clear to me that the concurrence's import was not limited to a short-term defense of trait selection laws as anti-discrimination measures. To me, it seemed the concurrence and its efforts to change the social meaning of abortion by associating abortion with eugenics in the Black community was perhaps part of a longer range strategy to destabilize and eventually overrule Roe versus Wade. So one of the distinct contributions of the paper is to explain how this could happen. As I explain, by associating abortion with eugenic racism, the box concurrence lays a foundation for discrediting and overruling Roe versus Wade on the alleged ground that the abortion right is rooted in and tainted by racial injustice, specifically the eugenic effort to selectively target and impede Black reproduction. Because a stare decisis, a past decision like Roe, cannot be overruled simply because a majority of the current court disagrees with it. Instead, some special justification is required. Justice Thomas's association of abortion with eugenics begins to construct the case that racial justice is the special justification that warrants overruling Roe. The idea is that race and remedying past racial injustices may serve as a special justification for reconsidering past precedents. And again, this whole idea is well established in our constitutional history. In Brown versus Board of Education, the court famously revisited Plessy versus Ferguson, concluding that the earlier court had failed to appreciate the psychological damage of segregation on Black children, and noting the changed understanding of public education in our society. Likewise, in Loving versus Virginia, the court overruled Pace versus Alabama, concluding that its equal application theory was incorrect and focusing on the fact that Virginia's anti-miscegenation laws were undergirded by an interest in maintaining white supremacy. Indeed, just last term in 2020, we saw the same impulse in Ramos versus Louisiana, which invalidated Louisiana's policy of allowing criminal convictions to proceed from non-unanimous jury verdicts. The question of whether non-unanimous juries were consistent with the Sixth Amendment had already been considered in 1972's Apodaca versus Oregon. But the Ramos court nonetheless concluded that because Apodaca was out of step with extant Sixth Amendment jurisprudence, and because the Apodaca court had failed to consider the non-unanimous jury rule's origins in a Reconstruction era effort to entrench white supremacy, the 1972 decision could be properly reconsidered by this court and ultimately overruled. The court's disposition of Ramos suggests how Roe could similarly be revisited and overruled. For years, those opposed to abortion have argued that Roe lacks a foundation in constitutional text, was improperly reasoned, and has proven unworkable over time. Despite those efforts, though, Roe has survived. But Justice Thomas's racialized critique of abortion furnishes new justifications for reconsidering and indeed overruling this embattled decision. Specifically, it provides new factual circumstances steeped in race and racial animus that may suffice to render Roe, what Ramos called, a remnant of an abandoned doctrine. To the extent the box concurrence provides a path toward overruling Roe, its logic depends on Justice Thomas's effort to graft the history of Margaret Sanger and the birth control movement to the history of eugenics, and then to graft all of it to abortion. But as historians and commentators have noted, the history on which Justice Thomas relies is selective and incomplete. With that in mind, the paper's second distinct contribution is to supplement Justice Thomas's account of the racialized history of reproductive rights discourse. As I show in the paper, the idea that the association of race and reproductive rights emerging with Margaret Sanger and the eugenics movement of the 1920s is entirely wrong. The entire history of the regulation of reproduction has been shot through with questions of race since the days of slavery. And indeed, concerns about race shadowed efforts to regulate reproduction after the Civil War, through the 1920s and into the 1960s and the civil rights movement. As I argue in the paper, the idea that broader access to birth control and abortion are part and parcel of a broader effort to curb Black reproduction and to limit the political power of the Black community was first articulated by Pan-Africanists in the 1930s, and then was reprised by both the Nation of Islam and the Black Power movement in the 1960s and 1970s. In this regard, Justice Thomas is not writing on a fresh page, but rather is tapping into a vein of discourse that has been in circulation in the Black community for some time. The trouble, of course, is that the view that family planning is part of a racist conspiracy to marginalize and subordinate the Black community is not shared by all within that community. Civil rights leaders of the 1960s, including Martin Luther King Jr. and Malcolm X, were supportive of family planning measures on the view that being able to control the size of one's family was an important element in stabilizing the Black community's economic circumstances. And as importantly, Black women in the traditional civil rights movement and in the Black Power movement vehemently voiced their objections to what they saw as a masculinist association between abortion, contraception, and genocide. So women like Shirley Chisholm and Toni Cade Bambara and Angela Davis and Florence Kennedy all made clear that if the concern was racial genocide, the problem wasn't broader access to contraception and abortion for Black women, but rather state-sponsored sterilization abuse, the injuries that were caused by unsafe and illegal abortions, and the challenging circumstances in which Black women were forced to raise their children. These, they argued, were the real sources of genocide within the Black community. In the paper, I argue that this more complete history is important for three reasons. First, overruling Roe on the grounds that it is a remnant of racial injustice depends on the history that Justice Thomas has crafted, a history in which the abortion rights founding moment is not in 1973, but rather is in 1923 with the eugenics movement. But as the paper shows, the history on which Justice Thomas relies is deeply contested, particularly insofar as it conflates the history of the birth control movement with the history of abortion regulation. More importantly, the history that I offer confirms that there were voices in the Black community who were distrustful of family planning and associated it with state-sponsored genocide. But meaningfully, there were other voices, particularly those of Black women who welcomed widened access to family planning as a means of improving their own lives and the collective fortunes of the Black community. Providing this counter history arms both reproductive rights advocates and members of the judiciary with a more robust historical account with which to challenge the box concurrence and the effort to reshape abortion doctrine and its social meaning. From a litigation standpoint, this may be especially important given the difficulty of verifying facts contained in amicus briefs that are submitted to the federal courts. Currently, Justice Thomas's historical count is the one that is being integrated into anti-abortion briefs in the lower federal courts, and there is no mechanism for challenging or contesting the content of those briefs. The history that I provide gives pro-choice advocates a means of challenging this historical narrative, or at the very least, it makes clear to courts that the history is more complicated than the Thomas narrative suggests. But this counter history doesn't simply serve a doctrinal or litigation function. It also serves a political function. If the box concurrence makes Black women unwitting dupes in a eugenic plot, or worse, willing co-conspirators, then this counter history actually surfaces the voices of Black women themselves and makes clear that they understood the claims of Black genocide, but they forcefully contested and rejected them. And that kind of representation is vitally important in the politics of judicial deliberation. As I suggest in the paper, when Justice Thomas speaks on the court about issues of racial justice, he does so with a kind of epistemic authority that comes from being the only African-American on the High Court. Likewise, the addition of Justice Barrett to the court may serve a similar function. When the question of Roe, or abortion more generally, comes before the court, as it will this term, Justice Barrett will likely be skeptical. But because she is a woman, her skepticism of abortion as a means of promoting women's equality and autonomy will likely be imbued with a kind of epistemic authority that may resonate, if not with her colleagues, then certainly with facets of the public. In a similar vein, Justice Barrett, who is the mother of 2 Black children and a child with Down syndrome, may also be vested with a kind of epistemic authority on the question of trait selection abortion restrictions functioning as anti-discrimination measures. Given that within the court, certain views and constituencies will be represented in deliberations on the question of abortion and its intersection with issues of race and inequality, it is our thinking about what constituencies will go unrepresented. And in this regard, the history that I provide gives voice to the concerns of Black women around these questions at a time when we are unrepresented among members of the court. Finally, the paper argues that the narrative that Justice Thomas puts forth in the Box concurrence is not just devastating to Roe and reproductive rights, it also has implications for the court's race jurisprudence. And to be very candid, this is a less fulsome aspect of the paper. It is primarily concerned with the impact on reproductive rights. But I do want to flag for those who are race scholars that there is also a residue here that may be quite relevant to the question of the court's race jurisprudence. If Justice Thomas has been transparent about his skepticism of abortion, he's been equally transparent about his interest in issues of race. He's weighed in very interesting ways in cases that very obviously implicate race questions, including in his dissents in Grutter versus Bollinger and Virginia versus Black. But he has also injected race into dialogues in which it wasn't immediately obvious that race was on the table, like in Kelo versus City of New London and McDonald versus City of Chicago. Accordingly, when I read the Box concurrence, it seemed unfathomable to me that Justice Thomas would go to such great lengths to engage the issue of race without intending for it to have repercussions beyond reproductive rights and to extend into the arena of race jurisprudence as well. So I'm convinced that this concurrence has implications for race jurisprudence, although I'm not entirely sure of what impact those implications might take. On the one hand, I think that Justice Thomas's reliance on the disproportionate impact of abortion among Black women may signal that although some members of the court have been unwilling to see disparate impact as probative of a racial injury, maybe there is more willingness to do so in certain circumstances, like abortion. Again, Justice Thomas seems to anticipate this critique in the Box concurrence. He drops a footnote to disclaim the prospect of a shift in disparate impact doctrine. But regardless, if the logic of the concurrence is successful in overruling Roe, it will do so at least in part by relying on evidence of disparate impact of abortion within the Black community. And that may suggest that there's perhaps more play in the joint on disparate impact issues. That is a very optimistic vision of the race landscape. And so let me conclude by indulging my more likely impulse toward pessimism on this front. The other place where the concurrence, I think, has implications for the court's race jurisprudence is in fashioning our understanding of what it means to have a racial injury. Part of what the concurrence does is to signal the kind of racial injury for which constitutional redress is available, and to ensure that the nature of that injury is actually quite extreme. Not just segregation or prohibitions on interracial marriage, but the kind of egregious evil that we associate with racial genocide and deracination. So to be sure, I am not certain what the actual outcome will look like for the court's race jurisprudence, but I think it is worth thinking more about. It strikes me that we have overlooked entirely, as we do with much of Justice Thomas's work, the way in which this concurrence is operating at multiple levels. It is a decision that speaks to reproductive rights, about the confluence of anti-discrimination law and reproductive rights, and then finally about race jurisprudence as well. And because it speaks on all of those levels, it will surely have a profound impact on decision-making at the court and the lower courts for quite some time. Indeed, just this summer, we saw a decision from the Sixth Circuit in another abortion case challenging a trait selection law where every single one of the opinions in the majority, including the majority opinion and several concurrences, all cited the Box concurrence. So this is very much in the ether. It is having an impact, and it will continue to have an impact. The question is what kind of impact that will take and what form that will take as we go forward. So I will stop there. I'm delighted to take questions from the audience, and it really has been such a delight to be here to share this work with you all. Thank you.
Thank you, Professor Murray. We would love to hear some questions from the attendees, but first, I have one question of my own. You kind of hinted at it in your concluding remarks, but your paper was published right before that Sixth Circuit case, preterm Cleveland versus McLeod, when it upheld that Ohio law that prohibited doctors from performing abortions if they knew the reason was because the fetus was diagnosed with Down syndrome. And that seemed to be kind of one of the first steps toward expanding the use of Justice Thomas's box concurrence. So I was wondering if you could elaborate on how that would be, how that shows that the rest of the justices would join in if an abortion case comes before them.
So it's a terrific question. When Justice Thomas wrote the box concurrence, it was a solo concurrence. Nobody joined him. And it seemed like there had been at least some discussion of the concurrence in conference because he felt compelled to drop a footnote rebutting something that Justice Ginsburg had said in her own separate writing in that case as well. But I think going forward, it is likely that Justice Thomas will find more congregants to this particular vision of race and reproductive justice as he goes forward. Certainly, I think this logic may resonate with someone like Justice Barrett, perhaps because of her own personal circumstances. As I said, she is the mother of 2 adopted Black children, as well as the mother of a child with Down syndrome. And so it may be especially resonant for that reason. But I also think for some of the other conservative justices, what we have seen since 2019, when the box concurrence was first announced, is that it's really been picked up in a quite thick way in the lower federal courts, in no small part because Justice Thomas has so many former clerks who are now in positions within the federal judiciary at both the district court level, but also at the circuit court level. So Judge James Ho in the Fifth Circuit has cited the box concurrence well before the preterm Cleveland case in Ohio. So this definitely has legs. If you look at some of the briefs that were filed before the court in Dobbs, the Mississippi challenge that the court will hear this year, they are also talking about the idea of abortion as a form of eugenics or a potential tool of deracination. And the Mississippi law that's being challenged has nothing to do with trait selection. So it is a durable, all-purpose logic that can be marshaled to contest any kind of support for abortion rights.
Okay, thank you for that. And it looks like Professor Cohen also has a question, so I'm going to go ahead and unmute him.
It's great to be able to unmute your professors.
No, it's a fun dynamic. And I'm sorry if I'm not sure if my video is showing up because I don't know if it works here, but thank you, Melissa. This was really great. And I was actually thinking along the same lines as what Emily was asking when you were talking about the ways that Justice Thomas has written about race in cases that don't overtly have to do with race. It made me think of Justice Kavanaugh's concurrence in the NCAA case. With Justice Gorsuch wrote a pretty straightforward antitrust opinion, and Justice Kavanaugh wrote a separate concurrence where he brought up race in the context of Black athletes being exploited by the NCAA, when obviously it wasn't the issue in the case, but he brought that up because of an amicus brief, and it was very interesting that he threw that in there. And I wonder if adding to your list of Justice Barrett and her maybe personal reasons for joining Justice Thomas's concerns about race and abortion, if that might have been an indication from Justice Kavanaugh, not that he was thinking about Roe, but just that he's receptive to similar arguments that what Justice Thomas was making.
Undoubtedly, it's a terrific example. And I think if you marry that example in NCAA versus Alston with Justice Kavanaugh's, I think, maiden opinion for the court in Flowers versus Mississippi, which was a Batson challenge case, you get a sort of thicker idea of his interest in being a racial justice warrior in certain issues. And of course, he was among the justices who formed that 6-3 majority in Ramos versus Louisiana alongside Justice Thomas and Justice Gorsuch. So I think it's not just Justice Thomas and Justice Barrett who will be receptive here. I think there will be other acolytes to this position. Justice Alito, interestingly enough, in Americans for Prosperity versus Bonta, the California disclosure law case that the court heard last year, was ultimately decided in a 6-3 decision with all of the conservatives in the majority. But at oral argument, interestingly, Justice Alito noted that even the NAACP had come out against the California disclosure law. So surely there were liberals and sort of woke elements on both sides of this issue, and this law was a bad idea. And we commented on it on strict scrutiny, because we thought it was so interesting that of all the briefs that had been filed in that case, and there were lots of briefs on both sides, but he completely honed in on the one filed by the NAACP.
I'll jump in here with a question if I can, Emily, if I'm allowed to. Thanks so much, Melissa. This is really, really fascinating. I was wondering if you could talk a little bit more about this vexing challenge of kind of the epistemic authority that we have now. We've had for a long time with Justice Thomas, and then this sort of additional complex wrinkle with Justice Barrett. And particularly, how we could think about trying to counter it or neutralize it, or at least kind of make it visible, right? Make this sort of work that it's doing a little bit more visible, so that maybe that can counter some of the power that it has. And whether that's us as observers of the court and academics and commentators, or for advocates, for people who are out there making arguments and trying to deal with the power sort of lying beneath the surface.
I think it's really tricky because the minute you sort of call attention to the idea of why does this person have the authority to sort of speak on these questions in this particular way, it immediately sort of gets reduced to a question of identity politics. But of course it is. Of course it is a question of identity politics. It was not a surprise or a coincidence that Justice Thomas was tapped to replace Thurgood Marshall, right? I mean, that wasn't a coincidence at all. There was no way the court was going to be an all-white court after Thurgood Marshall. The question was there an acceptable conservative who also happened to be Black or a person of color that might replace him? And there was Justice Thomas. And, so you have this sort of weirdly opportunistic moment where he is on the court reflecting a particular identity, and in times invoking that identity in particular ways for particular purposes, but the public can't really call him on it. And I think it is even more pronounced with Justice Barrett. And President Trump, in making the selection of Amy Coney Barrett to replace Ruth Bader Ginsburg, was very plain about it. When they were trying to figure out who would take the seat that Justice Kennedy had occupied, there was all of this discussion. A number of judges were floated, including now Justice Kavanaugh and now Justice Barrett. And Donald Trump said, I think before the press corps, I'm saving her for Ruth Bader Ginsburg, right? It wasn't a coincidence. It was one for one. And there's been lots of discussion, I think certainly among conservative news sources and media, and I think I cite one of them in the paper, that it could not be the case that a conservative majority of the court, whether it was a 5-4 majority or a 6-3 majority, it could not be the case that a conservative majority of the Supreme Court could overrule Roe and there not be a single woman in the majority. And so there was a need, if your goal was to overrule Roe, to have representation of that perspective on the conservative wing of the court. And for that reason, she was tapped. She was also, I think, tapped to, again, reflect that she was stepping into the shoes of another woman, but also, I think, for the purpose of sort of crafting a different kind of feminist vision than her predecessor. And so it is very hard to talk in terms of identity around the Supreme Court, because everyone sort of feels like when you talk about identity, you're not necessarily talking about merit or qualifications, but obviously all of this is bound up and everyone on the Supreme Court is qualified to be there in terms, but there are those on the court who I think are there purposely to reflect particular positions. And I would say Justice Barrett and Justice Thomas do reflect particular positions.
Thank you. I guess in that sense, who do you think on the court is most likely to surprise us in whichever direction when the next abortion case comes before them?
I don't think there will be any surprises from the liberal wing. I think there are 3 liberals who are there to do their best to cobble together something that looks like an abortion right in the face of what will likely be a very concerted assault on it. I think the real question is, if there are surprises, they will be small surprises and who they will come from. I think the Chief Justice has been surprising, if you will. He was surprising in June Medical Services in 2020, although interestingly, his surprise was to kind of do a Trojan horse and preserve abortion rights, but also decimate whole women's health versus Hellerstedt as a standard for states and courts to use in weighing whether or not an abortion restriction constituted an undue burden. So, you know, there are surprises and there are surprises. I don't know that I like any of the surprises that are available at this point.
And a question from Ashley. Do you think that optics or public perception will influence decisions going forward, given justices like Barrett spoke out saying the court justices are not partisan hacks?
Well, I think optics or public perception should factor into it to some degree. I mean, the court is unusual in our system of government in that it really depends on the public believing that it is legitimate for it to be effective in any way. Like, you know, what makes us abide by what the Supreme Court says? It's not because they have an army or because they control our budgets. It's because we believe that they are legitimate, that they're above the partisan fray, that they're making decisions that are principled. And, you know, interestingly, I don't think it was a coincidence that we got Gallup polling and Quinnipiac polling that showed the court's public approval ratings at its lowest point in the entire history of polling on the court. And then we had, you know, the court in full force, all four of these justices head out on the speech trail to disclaim the idea that they were partisan hacks. Side note to Justice Barrett, probably not great to say that you're not a partisan hack while you're giving a speech at the McConnell Center with Mitch McConnell flanking you on the dais. But, you know, those are just minor tweaks that you can fix. But it was, I think, quite unusual to see not just Justice Breyer, who's on a book tour, talk about this, but then Justice Barrett and then Justice Alito and Justice Thomas, which suggests, I think, that the idea of the public and public perception being at a nadir for the court has penetrated One First Street, and it likely should, right? This is an institution that has to be legitimate in order for it to work.
Thank you. And then I guess one thing that I'm wondering about is, as a lot of us here are law students, what can we do as we enter the legal field and we start our careers? And, you know, if some of us are interested in this realm, what can we do as young advocates to help in any way?
Well, so, you know, you all are in Philadelphia, a major urban center in a state that sometimes swings red, sometimes swings blue, probably has a tinge of indigo or violet. But one of the things that I've heard that I think is actually makes a lot of sense is, like, those of you who are equipped with this fantastic training, take it to some place where it's really needed. Like if a whole class of young professionals left like major urban centers like Philadelphia, like New York City, like San Francisco, and went instead to the heartland, places like St. Louis, like you could actually make a real dent, both in terms of your population and perhaps in shifting political power in those places, but also in terms of what you're able to do on the ground with your training. You know, there are places in Missouri where abortion rights really at a standstill. If that's something you care about, there's a place there to do important work in trying to preserve access as an advocate. There also may be opportunities to get in on the ground floor in public office and really sort of work your way through the state levels in order to make a change. I mean, we are all so focused on the Supreme Court and what's going to happen in Dobbs in Mississippi, but where were we when the Mississippi state legislature was passing HB 1510 in the first place? You don't get restrictive laws like that without state legislatures that are passing them. So, you know, why aren't we running for state legislatures? Why aren't we running for school boards? Like getting in on the ground floor and some of that work. You know, we're also focused on this East Coast Amtrak corridor, but I think the real action for progressive change might actually be paradoxically outside of those traditional liberal bastions.
That's a really good point. And I think Professor Cohen had another question.
I don't mean to take up space if other people have questions, but I'm happy to ask more because I could do this forever. Melissa, I'm wondering, I hadn't really thought about who would write Dobbs specifically, but I'm wondering after everything you've said, if you think Thomas might be the one writing it, especially the way we saw Chief Justice Roberts sort of separate from the conservatives in the Texas case. And if he does, if you think, there's been talk over the past week among, conservatives that we now have the Thomas court. 30 years into his tenure, this is the Thomas court, not the Roberts court, it's the Thomas court. And if he writes Dobbs, will that make it true that this is the Thomas court? Forget about the chief.
So I think it really depends on whether the chief chooses to join the conservatives on this. Obviously, if he joins the 5 conservatives, and I do think there are 5 to do whatever in Dobbs, he can reserve for himself the prerogative of writing that majority opinion. And I think if he does, he writes a much narrower opinion, maybe one that does away with viability as a salient marker in the court's abortion jurisprudence, but stops short of overruling Roe versus Wade. And I can imagine him wanting to do something like that because this case will be decided in June 2022, roughly. And a few months later, we will have a midterm election. And I imagine the Chief Justice really does not want American women marching to the polls with Roe's death on their lips. So, maybe he's able to broker a kind of compromise position by prevailing to just sort of the broader institutional concerns among the other justices. And if he's able to do that, you'll have sort of a death by 1,000 cuts kind of situation. If he's not, I do think then if the conservatives are very much in favor of a more maximalist decision, one where they take up Mississippi's explicit invitation to overrule Roe and Casey, then I think it's up for grabs who gets to write this opinion. It could be Justice Thomas, who has been stewing about substantive due process and Roe and abortion rights for a very long time. So this would be sort of a capstone of his career on the court and truly the culmination of what I think he sees as his life's work here. But I could also imagine him wanting to wait, especially if they don't overrule Roe in this instance, waiting for a trait selection law, because that really would be the vehicle for being able to talk about the racial injustice. And so, maybe he wants to wait for that. I think it depends on what the court is willing to do in this moment where there's so much blowback around SB 8. The election is coming up. There is this talk of court expansion, although the commission meeting today doesn't seem to be going very far in terms of thinking about that at all. So maybe they're not so worried about that. But I think they know the heat is on them. And we know they know the heat is on them because they're all on this, we are not partisan hacks tour. But I really think it depends. And I'm not sure it's Justice Thomas. I think he might want to wait for the opportunity to make this a question of race. And it would be hard to do it in Mississippi, or maybe easier, but more of a reach, I think.
Thank you. I just want to, before this ends, put in a plug. If folks aren't listening to Melissa's podcast, Strict Scrutiny, with co-hosts Leah Littman and Kate Shaw, you really need to, because you'll get to hear Melissa talk like this about everything about the Supreme Court. It's just as brilliant and entertaining as what we heard today. So everyone should be listening to that. It's really wonderful.
Thank you for the plug. I appreciate it.
And I will co-sign on that. This is Brett Asbury, but yeah, such a privilege to have you here, Melissa, as always. So thank you, and good to know you from law school and throughout our careers, but so glad you're here, and obviously your work's amazing.
Oh, this is such a treat. I didn't expect you to be on this. So this, even if you are a black box, I love that you are here.
Listen, no, I'm here. Hey, no, I'm here the whole time. I'm trying to support you any way I can. Yeah, of course. Yeah, absolutely. Thank you, Melissa.
Well, thank you so much. It is honestly, I wish I could be down in Philadelphia with you. I hope we'll have a chance to see each other in person, but again, you have such an embarrassment of riches on your own faculty that I'm just honored and really touched to have been asked to do this. So thank you. It's been a pleasure to join their incredible company today.